Hello, and welcome to today's Commonwealth Club World Affairs program. I'm Melissa Kane, legal and political analyst, and your moderator for today. And it's my pleasure to introduce our special guest, Professor Leah Littman. Ms. Littman is a professor of law at the University of Michigan, and she's the author of a new book called Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. She's a former Supreme Court clerk and co-hosts the very popular podcast, Strict Scrutiny. Professor, welcome. Congratulations on your new book.
Thank you so much. I'm super excited to be here.
Why don't you kick it off by giving us a little preview of some passage from the book?
Sure. So I'm going to read a passage from chapter 2 that I hope will reflect the general tone and tenor of the book, as well as a overarching theme of the book to give you a taste. So here it begins. The idea that LGBT equality horribly victimizes religious and social conservatives is divorced from reality. It is, after all, a vibe. It is nonetheless a key element of the court's jurisprudence of conservative grievance. The law now reflects a persecution complex that imagines religious and social conservatives are the victims of a society that no longer shares their views, and it insists that the religious and social conservatives deserve judicial protection from the big bad gays who have convinced people that they should be able to participate fully in civic society.
And in reading the comments and reviews of your book, people really enjoy the very accessible way that you write, and they're really sort of the way that people who aren't lawyers can understand, even though you're digging deep into important topics. So, can you tell us a little bit about why you decided to write this book?
Yeah, so I think it really grew out of my experience clerking at the court 15 years ago. I was at the court when they heard the constitutional challenge to the Individual Mandate and Affordable Care Act and came within a single vote of dismantling that major legislation based on this bogeyman fear that one day the federal government would force people to buy and maybe even eat broccoli. And the challengers to the law depicted it as some great infringement on liberty to penalize people for not purchasing health insurance, as if there are just a ton of people walking around who desperately don't want health insurance and the big bad federal government made them get it. So I think my experience seeing the court come within a single vote of dismantling that law on the basis of that theory set me down a path of wanting to inform the public of what I saw the Supreme Court up to.
And how did you choose the topic? So you go we there's so many I think that you could have chosen, but you go through abortion rights and sort of LGBT rights, voting rights, the administrative state, and money and politics. But I mean, this book could have been 1,000 pages long, I think.
Yes, it definitely could have been. So first, I had to select topics because my contract limited me to up to 75,000 words. And then within that limit, I tried to select topics based on a range of different criteria. One is I wanted to pick topics that were obviously going to be significant for people's lives and that people would recognize individual stories that are told in the book, among their friends, themselves, their colleagues, acquaintances. So that was an important criteria. Second, I wanted to pick some familiar topics, on which some of the material covered might be familiar to people who don't follow the court super closely, but also weave them together with stories that are not as well known. So it was both familiar, but also expanding people's knowledge about the court. And then third, I tried to pick areas of law that I just saw susceptible to the most change and the most dramatic changes recently and honestly going forward as well.
And each chapter, and this is again something a lot of reviewers loved, I really enjoyed, has a sort of pop culture touchstone that you weave throughout the chapter. Can you talk a little bit about coming up with those stories and how you decided to weave them in?
Yes. So I wanted to write a book that was accessible to a general audience. I also knew in a lot of ways the story I was telling was not a very happy one. So I needed to make it accessible and also digestible and manageable in certain ways. And pop culture references were a way of adding some levity to the stories, but also trying to draw analogies that almost cut the justices down to size or made people see what they were doing maybe in a different light than they had thought about before. So I just thought, what is the story I am trying to tell in a chapter? And then I would rack my brain. Well, what is a movie, book, television series that I think captures this shtick. So, for the chapter on reproductive freedom, which is, in my view, a story about a backlash to feminism and women's rights, the Barbie movie came to mind because, of course, Ken wants to make Barbie land into a patriarchy. So, that was the pop culture motif that I selected for that chapter.
The Kensurrection. That's really interesting. And there isn't a lot of reverence for the justices in here. I mean, you're not afraid to sort of get personal, given some of the things that the justices have said publicly. You really aren't afraid to take them to task. Have you gotten any feedback on that? On just sort of what is this? What is this book? The people who are reading this book may have an idea about the Supreme Court that you're definitely trying to sort of shoot a hole through.
Yeah, so I think people have responded in different ways to the pop culture references and the tone. I think for some people it is fun and, moments of humor that they enjoy reading in the story and makes them giggle. That is what I think I had wanted to do in part. For other people, it is a way of personalizing the court and the justices in a certain way. So trying to bring them back down to reality or liken them to something that is a little bit more ridiculous than them appearing in their black robes with a lot of pomp and circumstance often presents them out to be. So I think other people are a little bit taken aback when they read some of the opening chapters or some of the I don't know, analogies that I draw between, let's say, the Republican appointees and the mean girls from Mean Girls, but I hope it I don't know, is at least enjoyable to many readers.
Yeah, because to your point, I mean, there's not a lot of great news in this book. So it is nice to keep people entertained. And did you have somebody in mind? As when I write, I think about my mom who is smart and busy, so I sort of think of her going through her day and what would she be interested in? How deep should I go for someone like this? Did you have someone like an audience member that you kept as a touchstone?
Yeah, so I rotated back and forth between imagining my sisters reading the book, or my good friends from college who aren't lawyers, or my good friends here in Ann Arbor who aren't lawyers, but smart, interested, busy, as you say, people who care to learn more about the relationship between the court, politics, law, and society to understand how we got here, where the court might be going next, but they don't have the time to read every single massive Supreme Court opinion that comes down and listen to all of the 2 to 3 hour long oral arguments in all of these cases as they happen.
Now, you start. Let's go through the different elements of this. I'd love to start talking about vibes because you do talk a lot about it. It's a great word. It can be used to mean a lot of different things. But broadly speaking, I get the sense that what you mean by vibes is something like Republican politics or Republican Party influence.
Yeah, so vibes are meant to draw a pointed contrast to law. So law is more objective, determinate. Vibes generally refer to feelings, zeitgeist, atmosphere, those more loosey goosey things. Because it is a Republican supermajority court, those feelings, talking points, zeitgeist are those of the Republican Party and the conservative legal movement. But vibes more generally could just be atmospherics or feelings of anyone who is in a position to shape the law.
And it is one of these things that, I just hate to think about because I do have respect for legal institutions that the justices are being influenced by party politics. And but I had a little difficulty figuring out sort of what was it, the chicken or the egg? Like, were they appointed because they align, or do they change their views to amend themselves to the Republican Party talking points? What's your take on that, and whatever evidence there is to say one way or the other?
Yeah, so I think it's a both and situation. I
Mhm.
think the justices were selected in part based on views that they were known to have or they had established when they were already on the court as a judge on the Court of Appeals. So, Justice Barrett, before she joined the Supreme Court, she was a lawyer for the Bush campaign legal team. She signed a newspaper ad that called Roe barbaric. I think that those were probably two pieces of evidence that were marks in her favor when President Trump and the Republican senators were thinking about whether to select her and then to confirm her. But I also think that the ecosystem that has developed around the Supreme Court and within the conservative legal movement in particular has become a pretty effective mechanism at socializing the justices in what it means to be a Republican legal elite, what it means to be a conservative. And I think in some ways, the best piece of evidence for that is the evolution of what's known as the Chevron doctrine. So it's a pretty technical area of law, but Chevron just was the rule that courts would defer to an administrative agency's reasonable interpretation of a statute they administer. So we're talking about the Clean Air Act. That would mean if courts weren't sure what the Clean Air Act meant, they would allow the EPA to adopt a reasonable interpretation of that statute. When Chevron was initially announced, it was lauded and embraced by the Republican appointees on the court and among conservative legal circles. At the time Ronald Reagan was president, Chevron operated to the benefit of a Republican president at the time. Then what happens? Well, Chevron, when a Democrat was in the White House, operated to the benefit of a Democratic administration. And it didn't really allow the sort of deregulatory project that had motivated the Republican Party at the time and that they remained interested in. So what happened? Well, a bunch of Republican legal elites, Republican politicians, the Heritage Foundation, the Federalist Society, they began all of this programming, problematizing the Chevron doctrine, raising challenges to the Chevron doctrine, eventually coming around to the view that Chevron is unlawful. And what do you know? The Supreme Court justices evolve with them to a point where Justice Scalia, who had been one of the most vocal proponents of Chevron, later on in his career reversed course. Similarly, Justice Thomas, who had previously applied Chevron, reversed it. And so that used to be a doctrine that was embraced by Republican justices. They were for it before they were against it. And I think that is a story about the effectiveness of the institutions and culture around the court shaping the court.
Because you do talk about the justices going to events and really wanting the applause and the fancy dinners and things that Republican supporters can provide. But, and it's so hard to, and I don't disagree. I imagine them as having such huge egos. It's so strange to me that they would be, out there sort of fishing for compliments, given sort of how highly they think of themselves. But to your point, if it's changing in lockstep with the party, that does seem to be, some evidence that they're moving forward. Why have the Democrats been so bad about this? And I know that I don't expect your book to be everything to everyone, but they do have this pipeline, and you really do lay out very clearly, like, the long game that they're able to play in a way that it seems like folks on the left just haven't been able to do.
I think it is a combination of reasons. I think part of it is a story of the institutionalism that is a really strong force among the Democratic Party, particularly Democratic leadership, who has always felt a little bit reticent about challenging institutions. Their instinct is to defend institutions. So even when those institutions might be operating in highly imperfect, if not destructive ways, they still tiptoe around them. I also think it's partially a story of a lot of the senior Democratic leadership growing up and learning the law at a time when the Warren Court was the Supreme Court of recent memory and the court that loomed large. The Warren Court was a uniquely progressive period in Supreme Court history. And so when they think of, well, what does it look like for political officials to challenge the Supreme Court or to oppose the Supreme Court, they are thinking about the resistance to Brown versus Board of Education. And they can't get that picture out of their mind, even as women who are denied health care and, whose lives, health, safety, reproductive health is jeopardized when they are the ones criticizing the court and calling on the court to be reformed. That doesn't resonate any differently for them, and they continue to process that in terms of the Warren Court and at that level of generality. I think some of it is just an unwillingness to see things the way they were. So one of the examples I give in the book is Planned Parenthood versus Casey, the 1992 decision that opted not to overrule Roe versus Wade by a 5-4 vote. what was the conservative legal movement's reaction to that decision? To get very angry, to promise no more suitors, as in David Souters, one of the Republican appointees who had decided not to overrule Roe. So they doubled down and decided to fight harder to overrule Roe. What did progressives do? They looked at Casey and thought that settled for all time the constitutionality of abortion rights. They are never going to overrule Roe versus Wade. So even as Republican presidents continued to promise to appoint justices who would overrule Roe, even as they refined the judicial selection machine, Democrats didn't believe it would happen. So they didn't adopt federal laws protecting abortion rights while they held both houses and the White House. So I think it's a multi-part tragedy.
Yeah, I mean, as I'm reading through the chapter on abortion rights, obviously, the usual suspects are there, but you lay out so clearly this line of reasoning and how, you know, folks were saying for a very long time, this is what we want to do. This is what we're going to do. We're going to be chipping away. We're going to be appointing justices. And the Democrats were like, no, 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 it's fine. Like where, why wasn't anyone sort of hearing these very clear messages that were being sent, opposing Roe versus Wade. So it is a little frustrating. And again, I don't want to take the book into, what it's not there to address. But I think it's important as we're reading through this to think about where the Democrats have been while all this has been sort of lumbering along. You also write a lot
Send the
about
book to your local Democratic leader challenge.
I'll send it to Nancy Pelosi. Here, here's a copy. Uh, so you also write a lot about minority views. I mean, you have fringe theories here, but I think that it is tied in with the idea of minority views being put forth by the justices. And just as a theoretical exercise, I'm not sure that that's inherently a bad thing. I mean, I think
Yeah.
the court has protected minorities in a lot of instances. So can you talk a little bit about what's problematic about minority views in this situation?
Yes, absolutely. So I think the Supreme Court, its design has always tried to strike a balance between independence and accountability. The justices, of course, are not elected, they're not subject to reelection. On the other hand, they are selected by politicians, and the Supreme Court's jurisdiction is susceptible to Congress's control. So they're neither completely independent of politics nor are they engaged in the same politics as Congress or the president is. So I think that design has spawned a story under which the Supreme Court is supposed to protect minorities who are unfairly victimized in the political process. I think, however, that story is a little bit more fantasy than reality. I think if you look over the Supreme Court's history, the court has been quite reticent to get out ahead of the political branches. And some of the most famous examples of the court purportedly protecting minority rights, I don't really think track that story. So if you think about Brown versus Board of Education, for example, the historian Michael Klarman has suggested that, in fact, national public opinion was not really out of step with the Supreme Court's decision in that case. And in fact, the president ended up siding with the Supreme Court when states resisted it. Congress ended up passing civil rights laws that prohibited discrimination in education, in places of public accommodation, in voting rights, in housing, and elsewhere. So many of the examples that we like to think of as instances where the Supreme Court stood bravely alone against a majority of the country and the political branches are, I think, a little bit more complicated than that. But that being said, I agree with you that just because the court is protecting a minority or doing something that a majority of the country might disagree with, that doesn't make it inherently problematic. I do think what is different about the modern court, however, is two things. One is the frequency with which they are doing that, and the fact that their decisions are appealing to an increasingly narrow segment of the country and basically the same narrow segment of the country. So it's not like they are reaching different decisions that occasionally resonate with different groups, or sometimes reaching a bunch of decisions that side with the majority and only infrequently siding with a minority. It is instead a repeated effort to cater to a Republican Party that does not enjoy majority support, at least on many of the issues that the court is siding with them on. And second, part of the fringe theory aspect is the degree to which the court is entrenching minority rule. the ways in which they are making our democratic system less responsive to majority sentiment. So it's not just the court that is insulated from the will of the people or democracy. They are allowing Congress to insulate themselves from the will of the people by engaging in partisan gerrymandering. They are allowing Congress and the president to do so by authorizing them to engage in voter discrimination or voter suppression, by authorizing untold, unseemly amounts of money in politics that allow billionaires to outspend everyone else and drown out other people's views. So I think they are enabling fringe views and minority rule by making our institutions and country less democratic.
Well, and I think that the political spending one is maybe the fringiest of the fringe. So because you think about like people who want to overturn Roe v. Wade, like there's like 40% or so of the population. That's not. I don't agree, but they're not QAnon. But the idea that put forth by the justices that money in politics does not sway votes, that does not compel, sort of behavior that is in line with the source of the funds, is absolutely just one of those things that makes your jaw drop when you're reading the opinion. Can you talk a little bit about that? You have a whole chapter here describing sort of how this has all come about and the consequences.
Yes. So I think the reasoning in those opinions are so stunning if you look back on them and think about how that cashed out in the most recent election. In Citizens United versus Federal Election Commission, which in many ways is the case that set the Supreme Court down this path of dismantling campaign finance regulation as we know it. There, the justices declared that unrestricted corporate spending would not give rise to corruption or even the appearance of corruption, nor would it cause Americans to lose faith in democracy. And I think, okay, if the richest man in the world could spend several hundred millions of dollars and basically purchase himself access and influence over the presidency, the most powerful office in the world, I think that does give rise to the appearance of corruption. I think that does cause Americans to lose faith in democracy. And I think polling backs that up. And I think the through line that really unites so much of the campaign finance regulation with their decisions on political corruption, as well as their own behavior, is this idea that influence and access, even when it's purchased, is never corrupt. In their minds, the only real kind of corruption is quid pro quo corruption, where a businessman offers a bunch of money to a politician and says, if I give you this money, you have to pass this policy or vote against this law. But that's not the only way corruption works. I think giving someone access to an official, allowing them to prime the official, cozy up to the official, exercise influence, I think that is a kind of corruption that, again, reasonably causes people to look at our system of government and think, this is not one in which my voice is being heard in the same way as someone who can buy themselves access to the presidency.
Well, I mean, is that a hypothetical? Yeah, I assume.
Hypothetically speaking.
I assume someone like, I don't know, just maybe Elon Musk. It's one of the in a world of fractured alliances and where no one agrees on anything. I think this is one of the things. Like if you made a nationwide referendum on, say, Citizens United, it would absolutely pass by 99% of of the voters. People on both sides of the spectrum can see how bad this is. Because look, I live in San Francisco. We don't see Republican ads. Like the money,
I live in
the money
Michigan.
I see is on the
see
left.
a lot of them.
I bet.
Let me tell you,
Nothing but.
the last election cycle, that was a rough one.
You just forget it, turn it off.
Yeah.
I'm sure your local TV stations were thrilled, but we don't see Republican money here necessarily. We see a lot of money on the left, but it's as distasteful to watch.
Yeah.
It be the relationship between that and success here, as is anywhere. And I think it's one of these sort of very few issues upon which a number of people, a vast majority of people, will agree. And I think that kind of makes it really, really fringy. When it comes to the administrative state, this is one where I think somebody like you can be really effective because it is a very boring thing, and they need someone. The world needs someone to make it interesting, to make it accessible, and to get through the importance of what the state does and what these kind of changes mean.
Yes. So the administrative state chapter is about the Republican Party's efforts to undermine the administrative state, by which I mean all of the agencies that make up a big part of the federal government. And this chapter, I think, reflects a conservative grievance complex in the same way that the other chapters do, but in a way that less people might know about. So in the chapter, I talk about this memo that was commissioned by the Philip Morris Company, a tobacco company, and they asked this person, Lewis Powell, if his name sounds familiar, he would later be selected for the Supreme Court by Richard Nixon. They asked him to write a memo about how they could fight back against regulation. Tobacco industry didn't like regulation. And he writes this memo in which he says, it's no exaggeration to say that the most forgotten man in American politics is the corporate executive. As if the poor corporate executive is so put out because they are just so hurt by this regulation. They just want their voice heard and no congressman will listen to them. And he encourages that poor corporate executive to train their eye and find solace in the federal courts, which he described as the most promising arena for change. And part of the modern Republican Party and conservative legal movement's focus on the courts is attributable to corporations, big money, corporate executives galvanizing around the idea that the federal courts would be the most promising arena to fight back against regulation. So over time, you saw Republican administrations appoint people to lead agencies who didn't want the agencies to do much of all, much, if anything. So we saw that during the first Trump administration. Again, this dates back to Ronald Reagan. We saw it during the Bush administrations as well. And over time, they also are looking for judicial nominees who are skeptical, I think would be a nice word, of the administrative state. So, as Donald Trump is running for president, a judge on the U.S. Court of Appeals for the 10th Circuit named Neil Gorsuch wrote an opinion in a pretty minor, technical, wonky immigration case. And he wrote the majority opinion, finding, that the immigrants' claim succeeded. He also wrote an entirely separate opinion, even though he had written the majority opinion, in which he said courts needed to confront the elephant in the room, the behemoth that is the administrative state. And he launches on this long tirade about the constitutionality of agencies as they are structured. And I think that was really his effort to put himself on the map and in the lead for an appointment to the Supreme Court in a Republican administration, because that was very much a focus of the conservative legal movement and Republican Party, is courts' willingness to rein in, if not dismantle, the administrative state as we know it. And indeed, after the Supreme Court, the Republican justices overruled the Chevron doctrine, the New York Times ran a report quoting Mitch McConnell, among other people, saying, people thought all we ever talked about was Roe versus Wade. Reality is, we have been very focused on this administrative state as well.
Well, it is. We need to talk about Congress, I think, as well, because I mean, when you talk about the problems of the administrative state, like the administrative state is not perfect, right? To some degree, you do get the sense that Congress kicks things to the agencies. Maybe no one wants Congress figuring out like how many particles of lead per billion are allowed, right? That's not really for Congress, but it does seem like they kind of delegate, I'll just say that, quite a bit to agencies that may be the thing that sort of gets people's hackles up. But Congress itself has been be sort of unable to really act in a lot of ways, in ways that would really resolve a lot of these issues. Things like student loan debt and immigration. These are things that Congress could pass laws today, potentially resolving the legal issues at least, but they don't pass things anymore. So, so to what degree do you think that Congress is at issue, and what kind of things would you like to see, maybe in terms of the filibuster and things like that that might be helpful?
I wish Congress was not hamstrung by some of the problems that plague it, be it partisan polarization, partisan gridlock, Senate malapportionment, partisan gerrymandering, partisan polarization. I could go on. I do, however, think the story about Congress is one that is also linked to the Supreme Court in at least two different ways. One is that the court has actually taken away what would have been a pretty effective and potent tool for Congress to oversee the administrative state, and that was this mechanism called the legislative veto. And Congress had written it into almost 100 laws. And what it allowed was one house of Congress, by basically a simple resolution, to overturn a decision of an agency. And that mechanism would have given Congress way more supervisory power and oversight and control over what agencies did. The Supreme Court said that was unconstitutional. So I think the Supreme Court has played a role in lessening Congress's voice and Congress's powers over the administrative state. And then the second thing I would say is the Supreme Court has also weakened Congress's powers just on their own. In the Affordable Care Act case that I started out saying, that was a congressional law that the court came within one vote of saying was unconstitutional, exceeding Congress's powers in its entirety, and they invalidated in part the Medicaid expansion, which is a congressional law. The court has famously narrowed Congress's powers under the Commerce Power. It used to be the case that the Supreme Court basically said whatever Congress wants to do, if it concludes that this statute has a reasonable effect on interstate commerce, you do you, boo. Not so much. After Chief Justice Rehnquist became Chief Justice and Republicans gained more control over the Supreme Court, they began to strike down laws as exceeding Congress's powers. They've also narrowed Congress's powers under the Reconstruction Amendments. So Shelby County versus Holder, there the court struck down a Voting Rights Act that Congress had enacted and limited Congress's ability to address a serious national problem like voter discrimination. So I think the court itself has weakened both Congress's powers generally when Congress tries to exercise them, as well as Congress's powers over the administrative state in particular.
Yes, that is true. But we have this unprecedented, and this is for a lot of reasons, including Congress's sort of gridlock. But this use of executive power,
Yes.
use of executive orders as a way to get around
Yes.
Congress, and for many other reasons. But at least one purpose of them is to get around a Congress that,
Yes.
that isn't really necessarily acting on anything really but the budget. It seems. I think that's kind of
Yes.
their only job is to pay people.
All policy is tax policy now.
It's just one big controller is kind of what Congress is at this point. And the when you think about the filibuster, for example, something that Democrats did not like, and now they do, and it keeps flipping back and forth. But it does seem to be, at least in part, one place where kind of reforms can keep getting stuck,
Mhm.
reforms that could prevent some of these executive orders or
Yes.
challenges to the law. In terms of what you propose, it as what people can do after reading this book, that is, if you get to the end and you're at the bottom of the wine bottle, having read this book, you propose a couple of things that people can do so that they can feel they are taking action with regard to this branch of government that seems a little mysterious.
Yes. So one thing is just public information and public education. I think the Supreme Court is probably the least well understood branch of the federal government. It is the most difficult to follow. Their oral arguments aren't televised. We never know when they're going to release a particular decision. Sometimes they don't even announce that a decision is coming when it comes to their actions on the shadow docket or the emergency docket. So I think educating yourself and educating others about what is happening with the Supreme Court is an important first step to building a progressive base that cares about the courts. We were talking about earlier about the conservative legal movement and the Republican Party's efforts directed at the court. I think it is a mistake for Democrats not to incorporate the courts into their politics and political life as well. So I think that that is an important first step, just public information, organization, and education. And I think that that is a way of creating incentives for Democratic politicians to think about ways to potentially rein in the powers of the Supreme Court, or to make the Supreme Court more accountable to the people, or make its members more representative of the country writ large. So I think we need to create a constituency for people who care to have the Supreme Court protect those minorities who actually are unable to protect their interests in the political process, to have a Supreme Court that makes our country and our institutions more democratic rather than less. So I think that that is the end goal, but the little steps along the way begin with education, information, organizing, and voting.
Is it too pie in the sky to want change to the Constitution? I mean, one way to get certain rights into the place where they're unassailable is to put it right in there. California, right after Dobbs, we adopted a state constitutional amendment, sort of enshrining the right to abortion. And so, as unlikely as it might be, there might be some ways of actually sort of getting these things so that they can't be further assailed.
No, I think that that is a possible route, at least for some possible changes, whether it be maybe money in politics, as you are offering. That seems like an issue that enjoys not just majority support, likely supermajority support. I think there are other issues that fall into that bucket as well. One of them, I think, is partisan gerrymandering. I think a supermajority of the country doesn't like the idea that politicians get to pick their voters and politicians can write rules that allow them to stay in power even when a majority of voters want them out. So that might be another thing we could do by constitutional amendment. Honestly, I think presidential immunity might be one of those things. If you look at polling, the vast majority, I think over 60% of the country does not like the idea that presidents are above the law. So that too might be something we could accomplish by constitutional amendment.
Well, in your book, you also talk about term limits potentially for Supreme Court justices. What would that look like? Is it a term limit versus, say, like a retirement age, or what would you envision there?
Yes. So when I was talking about term limits, I was talking about just term limits. So defining the office of Supreme Court Justice just to be a term of 18 years,
Mhm.
that would regularize and routinize Supreme Court appointments so that when voters go to the polls, they know they are selecting a president who is going to select one or two Supreme Court justices. It prevents strategic retirements or unexpected deaths resulting in sudden dramatic shocks to the legal system that all of a sudden upend our institutions or our rights. I think that those would all be salutary developments. I don't think those are, however, a way of altering the Supreme Court that we have now. I don't think you can impose term limits on justices who have already been appointed to the Supreme Court when the term of a Supreme Court justice was understood and defined to be life. So this is more of a just forward looking perspective reform.
And that would have to be an amendment, right? A constitutional amendment. Presumably, it wouldn't have to be they would just invalidate the law.
Well, so I think this is actually susceptible to some debate. I am personally of the view that it would be constitutional for Congress on a forward looking basis to define terms of Supreme Court justices as just 18 years and allow them to hold those offices for good behavior. I do acknowledge there is a debate on this. I am also very much in agreement with you that if that issue went up to the current Supreme Court, they would definitely declare it unconstitutional. I think one important animating principle of the current court is this idea of judicial supremacy, that judges should have all of the power they have now, if not more. So I don't think that this Supreme Court would allow Congress to adopt many or any of the reforms that might rein in the court's power.
It's a pretty good gig if you think about it. Just,
Yeah.
any limit on me, just ask me, I'll tell you.
Exactly. Can I receive gifts and free personal or private jet trips? Yes, I conclude.
I've thought about it. Yes. And also, we also have a question here from the audience about expanding the Supreme Court, which is something you talk about in the book as well as a potential way forward. What would that look like?
Yes. So when people talk about court expansion, they're usually talking about adding a number of seats to the Supreme Court. It's usually framed in terms of allowing a Democratic president to appoint justices such that there's no longer a Republican supermajority on the court. Another way of court expansion, though, would be imagine expanding the number of justices to an even number such that, you know, the Republicans get half of the appointees, Democratic presidents get the other half of the appointees to make a kind of evenly split court. That would be another form of court expansion. So I talk about court expansion as a reform. I don't think it can be the only reform that is directed at the Supreme Court, just because I don't think it would solve some of the problems, like the court having too much power and being too unaccountable from the people and regularizing Supreme Court appointments. But I do think, as we were saying, because the current Supreme Court would likely invalidate any measure designed to rein in their power, that Supreme Court expansion is a necessary accompaniment or side dish to things like term limits or efforts to control the court's ability to select their own cases, because I don't think those are measures that the current court would allow Congress to do.
Do you think a real movement to expand the Supreme Court would, like it did back when FDR was president, scare them a little,
Yeah.
get them to come on back to doing some things that are supported by the majority?
Yeah, so just to quickly tell the story of the switch in time that saved nine, so people understand Melissa's reference. So, in the lead up to the 1936 presidential election, as the Supreme Court is striking down minimum wage, maximum hour legislation that is designed to alleviate the effects of the Great Depression, they are also striking down New Deal legislation adopted at the federal level. FDR campaigns in part against the court at the Democratic National Convention. You have the Senate Majority Leader also campaigning against the court. FDR is reelected in a landslide. He gets super majorities, sweeping majorities in the House and the Senate. And he proposes a plan to add seat to the Supreme Court for every justice over a certain age, which would have allowed him to appoint and enjoy a majority of the Supreme Court. Curiously, I think within weeks after he has his fireside chat with the country about said court expansion proposal, one of the justices who had previously been invalidating maximum wage or maximum hour minimum wage legislation switches his vote and upholds a minimum wage law. And that's referred to as a switch in time that saved nine. That justice also begins to uphold the New Deal program. So the thinking is justice switched their views to save the size of nine justices on the Supreme Court. I don't personally think that is as effective of a solution to the kind of court we have now for a few different reasons. One is I think that movement was very much focused on almost a single issue about the Supreme Court, which was its approach to economic inequality and efforts to alleviate the Great Depression. And I think it is possible to get the court to hold off, right, or modulate its views when you're talking about a single issue. I think doing so across a broad swath of issues is just a little bit more difficult because the signaling function and the messaging is just going to get more diluted and watered down. Second is, at the time, our democratic institutions were such that when there was majority support, supermajority support for the New Deal, the results of the elections tracked that. I think the reality is, because of Senate malapportionment, partisan gerrymandering, electoral college, voter suppression, money in politics, our institutions are now less responsive to majority rule. So sustaining that kind of pressure campaign and public outrage that is backed up by a credible threat of court reform or court expansion is significantly more difficult today than it was in the mid 1930s when FDR and the Democrats carried it out. So I think there's just a combination of different reasons that make it a little bit less likely today as a more permanent solution than I think it functioned as, now almost a century ago.
Okay. Understood. Understood. Well, I do want to make sure we have some time for audience questions here. We've gotten a few through the chat. One question: if you could add additional chapters, if you weren't constrained by the word count, what issues would you have wanted to cover?
Okay, so two things come to mind. One is the chapter that's right now on the administrative state had previously had half of an additional chapter on presidential power as well. And that is a portion of the chapter that I wish I could have kept because it described the Republican Party's simultaneously embrace of presidentialism and its hostility to the administrative state. And I'm able to talk a little bit now in the final chapter about the unitary executive theory and that vision of presidential power. Of course, I wish I would have had the opportunity to say more. So that's definitely one topic. The second topic is immigration. I wish I would have been able to tell the story of the Supreme Court's role in fashioning the current law of immigration. I think this is another one of the stories that really challenges the view of the court as a minority protective institution. And it shows the justices really echoing the political, very xenophobic talking points of the day. Around the same time, Congress is enacting the Chinese Exclusion Acts. You have Supreme Court justices parroting those same talking points and upholding them.
Excellent. What about affirmative action? That's another one that I don't know, it's a little quiet right now, but
Yeah, so I definitely think affirmative action is very important. I think had I included it, I probably would have folded it into the chapter on voting rights because I think that the hostility to affirmative action is part and parcel of some of the hostility to the Voting Rights Act in particular, and the Voting Rights Act's attempts to ensure that voters of color, Black voters in particular, had opportunities for political representation. And some of the same challenges to the Voting Rights Act are very similar to the challenges on affirmative action. One other one, the Second Amendment. That's the one that also could have used a chapter,
or,
maybe in the
or
sequel.
a book. Yeah.
Yeah.
All right, I got a question here. If the Trump administration refuses to comply with a Supreme Court ruling, what happens? I'm sure you get this a lot, so let's hear it.
I do. Okay. So I think it's important to understand that courts have a variety of tools at their disposal for what they do in the event of noncompliance. And those tools kind of fall under three buckets. One is criminal contempt, the other is civil contempt. And the other is kind of escalating injunctions and involving U.S. Marshals and the Supreme Court directly ordering contempt, which they did in this case, older case, Ship. So criminal contempt is already kind of developing in the lower courts. Basically, a court finds probable cause that individuals violated their court order willfully. They refer the matter to prosecution. If you're thinking, wait, would the Department of Justice initiate that prosecution? Courts have the authority to appoint outside prosecutors to prosecute the case, and they could do so. If you're thinking, wait, but this results in a federal criminal conviction, the president could pardon. I agree, the president could do so. In fact, during the first Trump administration, Donald Trump pardoned Joe Arpaio for contempt of a court order. So that wouldn't be unheard of. That being said, I think it is important not to obey in advance in this posture as well. And just because it is possible the president might take steps to undermine efforts to ensure compliance with court orders doesn't mean courts should take those steps to try to ensure compliance with court orders and force the political salience of the issue, force them to pay the price, the political cost and capital for provoking this fight with judicial oversight. So that's the criminal contempt land. Civil contempt, that cannot be just addressed with a pardon or a non-prosecution decision. This is increasingly directive injunctions coupled with civil fines. Courts have the authority to attach the property of individuals who are in contempt. So again, this is leveraging their possibly personal assets for their unwillingness to comply with court orders. So that is another bucket that doesn't have the same back end methods of presidential obstruction. If you're thinking, wait, but the US Marshals who would enforce those attachment orders or contempt, they are subject to Department of Justice oversight and control. I agree with you and I hear you, but I think that the risk of the US Marshals refusing to carry out a decision of the Supreme Court would require basically all of the United States Marshals to agree to carry out an illegal directive that would upend our system of separated powers and the rule of law. And this is where I think the broader public comes in. I think increasing attention, making our voices heard, making public calls to ensure compliance with court orders and the enforcement of judicial judgments makes it easier for U.S. Marshals to carry out judicial orders in the event of contravening demands. And so it makes it easier for courts to press forward with attempting to ensure compliance with judicial decisions if they know that a broad swath of the public believes judicial decisions should be complied with. So I am nervous, and I think the Trump administration has, in my view, violated several lower court orders. But I do think courts have at their disposal tools they can use, and a part of me wishes they were more willing to use them at this point.
And it sounds like you are interested in some folks on the left really pushing these and not sort of, as you said, pre-comply, or I
Yes.
forget the term that you just used,
Obey
that
in
they
advance.
yeah, obey in advance, that they would be more aggressive at least forcing this, force him to pardon himself, force him to
Yes.
sort of take these extraordinary measures and at least be, sort of public about that. We've got Is there a solution to the problem that the Senate Oh, well, yes. Okay. So, sorry, this question just took me a second to understand. The question is essentially: is there a solution to the problem of the Senate being able to do what Mitch McConnell did and the other Republican senators, which is to say, we're not going to hear or we're not going to appoint any justices for 18 months or whatever it is, whatever it is remaining in the president's term of the opposite party? Is there a way to sort of force those confirmation hearings to happen?
Yes. So, two things. One is we can always try to write a better set of rules, enact into federal law a requirement, of filling Supreme Court vacancies within 3 months or holding a vote or at least hearings within 6 months or 9 months. But I think the reality is the Trump administration has shown that even the best written rules can be circumvented and evaded by people who care to circumvent them. So I think the solution is going back to what we were just talking about with compliance with court orders, public attention, public pressure, and convincing a majority of the public that it's deeply problematic to just hold open a vacant Supreme Court seat for political advantage and partisan control, and hoping you can convince enough people that that is true to alter the political incentives and to result in some political penalty for doing so in the next election. I think that that is going to be the most effective tack.
And we've got another question here. What do you think of the recent Supreme Court decisions on immigration? It seems to be, maybe you see a through line that I do not. It
Yeah.
seems to be sort of hard to predict what they're going to do on any given case. So what do you see?
Yes. So I'm just going to quickly tick through the cases that I'm going to try to summarize and identify some through lines through. So going, I guess, in reverse chronological order, there is the Supreme Court decision that allowed Donald Trump to end the temporary protected status program for Venezuelan migrants, basically withdrawing legal authorization to stay and work in the United States for several hundred thousands of Venezuelan migrants, rendering them undocumented and potentially susceptible to deportation. Before that, there was the 7-2 decision that said the administration's method of providing notice for potential Alien Enemies Act expulsions was inadequate. So the administration was providing just 24 hours notice in English only to Venezuelan migrants who it was shipping on a plane to an El Salvador mega prison, under their view, with no prospect of return, even if they were wrongfully deported. The Supreme Court said you have to provide them with more notice than that 24 hours English only with no information about how to challenge their detentions. Before that, there was the order that said the lower court had the authority to direct the government to facilitate the return of a man who had been wrongfully expelled to El Salvador, but the lower court could not direct the government to effectuate, i.e., actually carry out his return. Before that, the Supreme Court blocked a lower court decision that had paused all of the Alien Enemies Act expulsions and thereby cleared the way for the government to try to expel more people without due process. So, wow, a lot of different decisions going in seemingly different directions. I think the decisions reflect a few different things. One is, on some level, they want the Trump administration to deport people better. If you think back to the first Trump administration, they invalidated their efforts to try to add a citizenship question to the census or end the Deferred Action for Childhood Arrivals program. And their complaints with that were basically you didn't do so with good enough process. You didn't dot your I's and cross your T's. You didn't come up with a plausible enough lie. And so here they're saying you can deport, right? We just allowed you to strip legal authorization from, again, more than 300,000 people, the largest mass illegalization event in history. But in order to deport them, you have to actually comply with minimal deportation procedures. I think another through line is they want to retain authority, judicial supremacy, what we were talking about earlier. I think part of what is concerning to them about the Abrego Garcia wrongful expulsions case is, under the administration's view, they can ship people off. After they do so, courts have no possibility of ordering their return. That means courts might not have any opportunity to weigh on the lawfulness of detentions, because if they ship people off under cover of night without due process, you can't challenge in advance. And once you're expelled, you can't challenge after. So that impedes the court's ability to exercise legal control. And that was, in fact, one of the concerns that the justices identified in their 7-2 decision. Those are two through lines. I think the court also kind of wants to sometimes rule against and sometimes rule for the Trump administration in order to preserve some appearance of impartiality.
Some dignity. Uh, so we have a question here. Oh, if you could change one thing about the Supreme Court, what would it be and why? This is, I feel like you're now in a beauty pageant. If you could change one thing, what would it be and why?
It would be the 2016 presidential election. I would have Hillary win it.
All right, there you go, listener. All righty. In the research and writing the book, is there anything that you learned that shocked or surprised you?
I think some of what was striking to me is finding the language used in Supreme Court opinions, being able to trace it to political talking points that had emerged 50 years ago, in some cases 60, 70 years ago. So, for example, in striking down the Voting Rights Act, the preclearance process in Shelby County, Chief Justice Roberts wrote it that it unfairly punished the South for the Confederacy, the Civil War, and Jim Crow segregation and voter suppression. That was the same language that segregationist Strom Thurmond used to oppose the Voting Rights Act when it was enacted in 1965, calling it unfair, punitive, and selective and vindictive political legislation. So I think the striking similarities in the legal reasoning and the political talking points was striking.
The Taft administration, when I was reading the book, and I was like, oh, I didn't realize. The book goes into very deep detail on these topics, and it's, you don't need to be a lawyer to understand them, but you definitely get into the history going all the way back to the 1700s, 1800s with regard to women's rights when it comes to their pregnancy. I did a deep dive in the Constitutional Convention records a few years ago. And one thing that struck me, even as someone who has a lot of respect and deference to the document, is that they didn't talk about women, like, at all. And I mean this, at all. There are two references to women in the entire records of the convention. And so when you're thinking about things like originalism and these kinds of ways of interpreting the Constitution, and I'm not pro judging people by today's standards, but really, man, like, not even a mention. That was pretty shocking as well. So we've got another question here. How did you become interested in law, and who did you clerk for?
I clerked for Justice Anthony Kennedy on the Supreme Court. And how did I become interested in law? I loved my AP government class and AP US history class in high school. And then in college, I started out as a math major, ended up a chemistry major. I really liked organic chemistry. And I think the analytical elements of chemistry also attracted me to law. And I took a class on the Warren Court from a professor at the law school and absolutely loved it.
All I remember from con law in law school was it depends on the justice. And I remember like that's all the whole year. That's all I remember. Professor Schifrin. It depends. Like whoever's on the court. And I do want to ask you about this because I mean, reading these books, and I know that there are issues with the Supreme Court, but it's very hard for folks like us who have devoted our lives to the practice of law to think about these things. What has this kind of research? How has it impacted you personally, if at all, with regard to the way you view the world and you view yourself? Because you do try to end the book on a good note, but it's also a pretty dark description.
I think it is humbling to realize the length of time it takes to change an institution like the Supreme Court. And so accepting that the changes that I hope to see might not happen in my professional lifetime, might not happen in my lifetime, but still being willing to try to make them and put in the work to make them happen. I think holding both of those views is sometimes challenging. And I think trying to figure out a way to make those efforts sustainable without becoming discouraging or burning out is also something that I think about. And my particular coping mechanism tends to be humor. And that's part of why I wrote the book the way I did. That might not work for everyone. But for those who find that helpful, you will find that in the book alongside a lot of information about the court.
Well, and are you nervous that folks who, I mean, there are certainly, some burn it down types who will see your it's hard to say, oh, I want to criticize these folks because it's worthy of it and that's an objective thing to do, but also in the wrong hands or, in the wrong process of thinking, people can say, oh, well, this is great evidence that we need to do something really dramatic or drastic.
Yeah, I in some ways I do think we need to do something pretty drastic in that I don't think we can just hope things are going to get better and continue along what we have been doing and hope things improve. That has not worked and it has led us to where we are. So in that sense, I wouldn't mind if that is a takeaway from the book. And if that means some people find it off putting or they don't like the story, the book is not written for everyone. It is meant to be energizing and affirming, and in some ways to create a sense of community to make those who feel frustrated and almost made crazy by what is happening at the Supreme Court to feel less alone.
And so I do also have another question here about your background. What do you teach at the University of Michigan?
I teach constitutional law, federal courts, and then a rotating set of classes like judicial decision making, current issues in public law litigation, reproductive rights and justice, habeas corpus, and you name it.
And how are your students these days? Are they feeling optimistic or nah?
I hesitate to ascribe a single view to a group as large as law students at the University of Michigan, or
Fair.
even my classes in particular. I think it is a range of emotions. I think some students who came to law school envisioning themselves doing civil rights work knew they were going to be in a fight. I think other students, this has been a little destabilizing for them and affected how they see themselves and the profession they see themselves joining. And for other students, they are quite happy with, what is happening.
But generally not upset about their choice of, of profession.
No, I don't see a lot of students who think, in light of everything that is happening, I would prefer not to be a lawyer.
Oh, gotcha. Well, certainly once you're on the track, it is hard to get off. So
Yeah.
you're here. Okay. Excellent. Well, we have reached a point in our program. We have time for a final question. And what do we have here? Okay. What is the most important challenge facing our legal system? Like, forget just Supreme Court. Just you teach about federal courts in general, so we'll say federal court system. So you don't have to talk about probate courts or anything like that. But in the federal court system, are there other sort of larger systemic issues?
Honestly, I think the issue I am writing about in the Supreme Court has kind of pervaded the lower courts as well. Just in the last week, we had a decision out of the now infamous slash notorious particular judge in the Northern District of Texas declaring legal protections for the transgender community against harassment and guarantees of reasonable accommodation are apparently just categorically accepted from Title VII. The reasoning basically suggests that's because transgender people don't exist at all. And so I think reading some of the writings of the appointees on the court suggests something has gone deeply wrong with the nomination and selection and structure that has allowed these individuals to possess such sweeping power.
And sorry, I do have another question because we just had this birthright citizenship case come
Oh,
before
yeah.
the Supreme Court, and just as someone who's a scholar of the federal courts, this issue of nationwide injunctions was really the centerpiece. I know everyone wanted
Yeah.
to talk about the birthright thing, but that really wasn't the thing they were talking about. They were talking about this issue of judges, individuals like this person, being able to issue these injunctions that involve people who aren't actually in the court. So, can you talk a little bit about what you saw there at the Supreme Court and where you think that's going?
Yes. So I think nationwide injunctions are too frequently used and concerning, but I also think they are sometimes needed and should not be absolutely prohibited or declared unconstitutional. And I think the birthright citizenship case is a perfect example of a case that calls out for a nationwide injunction. Difficult to have state by state rules of citizenship. And I don't think administration should be allowed to implement wildly illegal policies on a state by state basis. At the oral argument, I heard reticence about nationwide injunctions, a concern for absolutely prohibiting them. I'm not sure I heard 5 votes to either completely prohibit nationwide injunctions. I also didn't necessarily hear 5 votes to clearly and cleanly just uphold the nationwide injunction in this case. So, if I had to predict something, my guess is the Supreme Court will ask the lower courts to use another procedure, make additional findings under the law or under the facts in order to warrant the kind of sweeping relief that they ordered. I wish that instead the Supreme Court would just order a supplemental briefing on the merits and decide the merits and therefore uphold the nationwide injunction. I, I'm waiting to get that supplemental briefing order, and it has not yet come.
Oh, well, excellent. Well, thank you so much. Many thanks to Professor Leah Littman, author of Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. We encourage everyone to pick up a copy of this Professor Littman's new book at your local bookstore. And if you want to become a member and support the Commonwealth Club's effort at making virtual and in-person programming possible, please visit commonwealthclub.org. I'm Melissa Kane. Thank you, Professor Littman. We will see you next time.